Hello. Today, in this video, we're going to cover the tricky problem of how to handle yourself when dealing with your government regulators when you know there may be an investigation and a prosecution around the corner. As corporate counsel, you're on the front lines when government agencies come to your door looking for information. This will happen frequently if you are in a heavily regulated industry like natural resources or financial services. And government agencies have significant powers to ask for information, whether it's an inspection, like going to a restaurant and looking at the kitchen, or asking for documents, like Revenue Canada employees asking for audit type information. In most cases, your company may want to or must comply with these government inspections or audits. Many statutes require you, as a term of your license, for your company to comply with ongoing monitoring, auditing, or inspection requirements. Also, in some cases, it may be a criminal offense not to cooperate or comply with the demands made of inspectors or auditors. Further, many companies have codes of conduct or other internal rules consistent with their social obligations to be seen and also to actually respect the demands of government agencies and regulators when they come asking for information. Under all of these circumstances, the first instinct of most companies, and especially corporate counsel, is to comply with these requests for information and cooperation from agencies. No reputable business wants to be seen as a bad actor. Everyone wants to do the right thing and to be seen to do the right thing. But this tendency can be abused by government. The case law and many cases are replete with examples of instances in which there is government overstep, where a government power for inspection or to compel an audit or for demand for documents is in fact misused, and then therefore the company suffers a consequence in a criminal or regulatory prosecution as a result of a wish to cooperate with government inspections. This is what I want to talk about today. The starting point of any criminal lawyer's approach to this problem are certain legal rights under the Charter of Rights and Freedoms, namely Section 7, 8, 9, and 10. Those are, of course, your rights against self-incrimination, rights from unreasonable search and seizure, and rights to counsel on detention or arrest. I know some of these sound very dramatic, especially in the corporate setting, but they have implications for your business. Most particularly, you have a right not to be compelled to give information against yourself in a criminal investigation and to have that information adduced in a trial, in a prosecution against yourself. It simply is seen to be unfair in the Canadian context. The courts recognize that regulated industries cannot function effectively or efficiently without the cooperation of those participating in the industry. For example, in the fisheries context, you can't run a quota system without requiring everyone to report the results of their fish on a daily or weekly basis. It just wouldn't work. On the other hand, the courts are very reluctant to allow someone who provides information for the benefit of the system in a criminal prosecution against them for criminal violations of the rules governing that system. It goes against the principle against self-incrimination. And so the courts have developed clear tests about when an inspection or audit or other compliance-related activities move into a criminal investigation. At a very high level, the Supreme Court of Canada has developed a test from a case called Fitzpatrick, which happens to be that fishing case that I talked about, that lays out 4 different factors that the courts will look at to determine whether or not a permissible regulatory exercise has moved into an investigation, and therefore the principles of self-incrimination should be respected. Those 4 factors include: 1, the presence or absence of coercion at the time that the information is being sought; 2nd, the nature of the relationship between the state and the person at the time the information is sought, and specifically whether that relationship is adversarial in nature; 3, the risk of an unreliable confession that comes from the exercise of that power; and 4th, there's an overarching concern from the courts to ensure that moment at which the information is being sought is not subject to abuse by the state. As a litigator, I'll tell you the battleground is on that factor dealing with what's the nature of the relationship. Was it adversarial at the time? And the courts will often look to a multi-part test that was developed in the case called Jarvis, which is a tax case, in determining whether or not the relationship of the state had turned from a cooperative, kind of an inspectional one, into one of a criminal investigation that might result in a criminal prosecution. And they'll look at things like, were there in fact reasonable and probable grounds at the time of the incident to warrant the inspector starting a criminal investigation? Whether the actions of the inspector or the auditor proceeded as if it was an investigation. Whether there was a referral to an investigative body. So for example, CRA has both civil and criminal investigative units. And so they will often look at, was there in fact a formal referral from the civil side to the criminal side? Was there a de facto investigation where the administrative side was using the tools that were more akin? Was there in fact communication between the criminal side and the civil side, where the criminal side are giving directions or advice to comply, or for the civil side to do or ask certain questions that are more akin to a criminal investigation, almost using the administrative side or the civil side as agents of the criminal side? And also the types of questions. Was the civil side or the audit or the inspection, were they asking questions that would really only be relevant to a criminal investigation? And oftentimes, for example, as a defense counsel, I'm looking for questions such as, well, what were you thinking? What were you intending? What were your motivations for engaging the behavior that you did? Because to an administrative side, all of those intention or the reasons why someone would have done something that was contrary to the law is irrelevant. It's only relevant if you intend to prosecute them as a crime that they intended to violate the statute. And so those types of factors are the types of things that let me as defense counsel know whether government agents have crossed the line into a criminal investigation. So as corporate counsel, a tricky job you have is knowing when cooperation with the government or your regulators might need to stop and when you need to get a bit more defensive because you are looking at a potential criminal investigation. So understand whether there has been a referral. It's okay to ask the government agencies, hey, inspector, has there been a referral to the criminal investigation unit or to the RCMP or to any other department more responsible for criminal type investigations? If so, you'll want to start asserting charter rights. Say, hey, I'm providing this statement, but I'm reserving my rights under Section 7, 8, and 9 of the Charter. Review those production orders. If you're being served with production orders requiring you to produce documents or to provide witness statements or chronologies, again, make sure you're documenting those production orders, the responses, and asserting your charter rights when you're making those answers. Document, document, document. I'm sure as corporate counsel, you're documenting everything and telling everyone else to document everything, especially when you know that something has crossed over into an investigative realm. Start documenting every single email, phone call, anything that could be used by defense counsel to establish that the contact that was inspectional has turned into an investigation. If it gets quite serious, and if the documentary or the evidentiary claims or demands are becoming quite onerous, consider the possibility of seeking judicial review to quash government action before it becomes an investigation. This can be quite pricey. Judicial reviews are not cheap, but if the stakes are high enough, it might be worth the investment. And finally, if you're not sure, and it starts to feel like this inspection or this regulatory inquiry is starting to turn into a criminal investigation, it's okay to ask for help and go outside to criminal defense or regulatory defense counsel. The skill sets are different, the knowledge base is different, and this law is constantly evolving. And so it is important that you bring in expertise who can identify exactly when the point moves at which you move from an inspection into an investigation.